Hi everyone, welcome to this webinar. We're going to get started in a few minutes. If you're arriving, it would be great if you could add into the chat your name, firm and role. And we also have a Q&A box that you can add in any questions as we go through the webinar. Just to let you know, we are live both on Facebook and we are now going live on Facebook Live as well as Zoom and recording this session. We'll get started shortly. Okay. Looks like we're live on Facebook, and I'll just give it a couple more minutes for a few more people to arrive. Share my screen. All right. So it's 1 o'clock. Let's get started. Welcome everyone to Family Property's Techy Tuesday. The webinar today is on family property tips to help with the new FCFCOA. Before we get started, just a few housekeeping things. We are live both on Zoom and Facebook Live, and this is being recorded, so we will send you a recording afterwards. We'd love if you can go into the chat box and introduce yourself, and there is also a Q&A box for you to ask questions, which we'll either cover verbally or in writing. I also wanted to acknowledge that this meeting is being held on the traditional lands of the Aroyan people and pay our respects to the elders, both past, present and future. So let's get started. For those who don't know me, I'm Fiona Kirkman. I'm the legal founder of Family Property, principal of Kirkman Family Law and an accredited specialist in family law, as well as a mediator, family dispute resolution practitioner. So I really bring that legal foundation. I know many of you, I really enjoy networking and learning what works for you, what doesn't, and getting your feedback on the product. Therese?
Hi everyone, I'm Therese Aroyan. I've been a family lawyer for about 10 years and I'm now working at Family Property as a product owner and project manager. I also obtained my accredited specialisation in family law in 2018 and I'm really excited today to be going through the rules with all of you.
And Tim?
Yeah, thanks. Hi, everyone. I'm Tim Kirkman. I'm the CTO with Family Property. So, yeah, I'm really involved in the product development, training, support, and all of those things. And, yeah, excited for today's presentation.
So the agenda for today, we've got quite a busy agenda that we want to cover off. One is going through the relevant rules and practice directions of the new FCFCOA, looking particularly at the pre-action procedures. I know there's a number of family lawyers as well as family mediators in this webinar, so this is definitely relevant for everyone in the family law sector. 3, we want to cover off disclosure and the new requirements for parenting disclosure, as well as the financial disclosure, the undertaking as to disclosure form, and compliance and how important it is to comply with both pre-action procedures and disclosure. We'll then discuss initiating proceedings and responding to proceedings, what forms you need to file, and how Family Property can assist in that regard, as well as what particularly you need to do if it's a financial matter versus a parenting matter. We'll then discuss dispute resolution, both pre-filing and also matters that are referred out to external dispute resolution after filing or in court dispute resolution. And hopefully we'll have time for Q&A at the end, although please ask questions in the Q&A as we go through the webinar today. And at the end of each slide, We want to make it more of a panel discussion between Therese, Tim and I, and any questions we have. So welcome any feedback or any questions. So if you haven't already, for those who've just joined us, I know there's lots of people joining us. If you can add your name and information into the chat and anything in Q&A. We've got people on Zoom as well as Facebook Live. Thankfully, Facebook's up and running again. So we'll be taking questions from both forums as well. And Chanel will be responding to the chat and Beth in the Facebook Live. So we may get started. Therese, over to you. Introduce us to the new rules.
Thanks, Fiona. Okay, so there are two sets of rules that are relevant for family law proceedings. There's the main Federal Circuit and Family Court of Australia rules. We'll be focusing on those today, and Schedule 1 of those rules. They are essentially an amalgamation of the family law rules and the Federal Circuit Court rules, and they're about 324 pages, so there's a lot in there. The Division 2 rules are also really, really important to have a look at as well. They're only short, they're only about 15 pages, but there are some main differences between the length of affidavits for interim hearings and the scale of costs that are applied on party cost orders. So that's really very important for you to also review. But yes, the purpose of today is to go through some of these rules in accordance with the case management listing pathway that's set out in the central practice direction that we're going to take a look at in a minute.
So Therese, as I understand, the Division 1 rules are really replicated for Division 2, but there's a different page limit for the affidavits, and some costs, including the scale of costs is slightly different, etc. But we'll be focusing on the Division 1 rules. Division 2.
That's right. We go on to the next page. Yes. So there are 18 practice directions in relation to family law proceedings, and those new rules that we just mentioned, they must be read in conjunction with the central practice direction, the Family Law Act, and the specific practice directions in relation to all these different types of matters. Rule 1.04 of the main rule confirms the overarching purpose that's stated in Section 67 of the Federal Circuit and Family Court Act, and that is to facilitate the just resolution of dispute according to law and quickly, inexpensively and efficiently as possible. So if we look at the central practice direction, what that does is it sets out the need to proactively identify the issues in dispute, gather and exchange evidence as soon as possible, emphasises the importance of dispute resolution. If there's no agreement, to file and serve as soon as possible so that the parties and the court can identify those significant issues and be fully prepared for court events. So when we look back at those numerous practice directions, it's really important that those practice directions are read in conjunction where they are related. So for example, in relation to financial matters, it may be that you need to look at the financial direction, the Bankruptcy and Corporations Act, if that's relevant to your particular property proceedings.
And this central practice direction, that's a mandatory practice direction that we should all become familiar with, and it's mandatory that we provide it to clients. Is that correct?
Yes, that's correct. And I think for the purposes of today, we're really focusing on the financial proceedings and the parenting proceedings directions. And all throughout this presentation, we have links to not only the rules, but also the different sections within those particular directions as well.
And after this webinar, in addition to the recording, we'll make this presentation available to you. So all the links will be there. But the central practice direction, that's one that you really should get familiar with. It's written in plain English. It goes through those 10 core principles that underpin family law under the FCFCOA, and there's a real focus on dispute resolution, compliance and cost management. Those themes really come through in that practice direction. I'll move on to the slide.
Next slide, yep. Okay, so this is the listing pathway that is set out in the central practice direction. This is the listing pathway for all family law proceedings except for urgent matters or matters in a specialist list like the Abbott list, the COVID-19 list, the Magellan list, complex property matters, or if this pathway has been varied by order. And you can go to Rule 1.07 to look at the different circumstances in relation to that. Thanks, Fiona. Otherwise, I think, yes, so this is that was the listing pathway that we were going to talk about the rules in the context of that pathway. And Fiona, did you have anything else to add in relation to that?
So we'll take a look at we're going to go through in this webinar the pre-action procedures, the first court event, briefly discuss interim hearings and the new application for a proceeding, and then the dispute resolution for parenting and financial referred out to external mediation or arbitration or internal. We're not going to cover too much as far as from this point on, but we will cover briefly the rules and how they relate back to the case management pathway. And so pre-action procedures in family property, we've now got a pop-up that Tim will shortly demonstrate with the relevant documents that should be provided to your client. Those include, as we've discussed, the central practice direction, which you should not only give to your client, but if the other party is self-represented, there's a requirement to also provide it to the self-represented party. Marriage, families and separation brochure. We should be quite familiar with that because that's the old brochure. It has been slightly updated, but that was a requirement that you would have to give those brochures to your client and serve them, say, with a divorce application. So that brochure is still required to be given. Before you file pre-action procedures for financial cases. So this is really important. There was always a pre-action procedure for financial cases in the family court, and same for parenting, but we really need to now be making sure that we go through all the obligations that the parties have and making sure that they are compliant. Really, step 1, step 2, step 3, it's really quite specific as to what the pre-action procedures are, and I'd be recommending you read this and tick off the boxes before commencing procedures, because there's really specific rules and specific compliance obligations there. Similar with parenting, there's a pre-action procedure for parenting, setting out what's required, when things are exempt, and again, listing the steps involved step by step as to what you need to do to comply with those pre-action procedures. Lastly, there's a new video, which I think is quite handy to show to your clients. I'll skip the ad there, but it's separate smarter video, which again must be shown to your clients before commencing proceedings. And for the mediators in the room, that's also a good video to show clients prior to mediation. That's one that I've added to my list. Lastly, duty of disclosure. So this form has been updated in light of chapter 6 of the rules, and sets out the financial disclosure that's required, but also the disclosure required in parenting cases, which we'll discuss shortly, and the need for undertakings about disclosure pursuant to Rules 6.02. It also lists the penalties, which we'll be discussing as well. So that mandatory information will showcase shortly how Family Property assists make sure that you are providing that information. We also have a bit of a poll here, so I'll launch this now. Can everyone see that? Yeah. Okay. Therese, did you want to cover pre-action procedures and the genuine steps?
Absolutely. So unless the party satisfy an exemption, there are specific steps that must be taken. Parties, in accordance with Rule 4.01, must comply with pre-action procedure. And luckily for us, they're very specific steps that are set out that we need to undertake. So from a lawyer's perspective, needing to provide pre-action procedure brochures to the other side, along with Schedule 1, inviting the other party to dispute resolution and negotiating with which dispute resolution service you will attend, to attend dispute resolution and make a genuine effort If you don't agree, you also need to serve a written notice of intention, and this needs to set out the issues in dispute, any orders you'll be seeking, and a nominated time for the other party to reply. And you need to provide at least 14 days from the date of that letter. If you're responding, your letter needs to set out the issues in dispute, orders you'd be seeking if the matter went to court, a genuine counter offer, and a deadline for response. And again, that's at least 14 days. Essentially, really, the court is seeking that parties take a sensible and a pragmatic approach, focus on what's really relevant, and only really press significant issues. But again, just noting that there are those exemptions to those pre-action procedures, and they are things like urgency or risk. If we move on to the next slide. Yes, so these are the consequences of non-compliance. So in relation specifically to non-compliance with pre-action procedure, there is the risk that if you haven't complied, there may be a stay of proceedings pending compliance. And considering orders for costs, the court would take into account when considering whether to make orders for costs a party's failure to comply with rules 4.01, 4.02 and 4.03, and also the involvement of a legal practitioner in a party's failure to comply. And Schedule 1, Part 1, Clause 2 and Part 2, Clause 2, they're just the different parts in relation to both financial and parenting proceedings. It goes into the example of what a non-compliance might be, and that is things like not sending that written notice that we just talked about, not providing sufficient information or documents to the other party, not following a procedure required by the procedures, not responding appropriately within the nominated time, and also not responding appropriately within a reasonable time to any requests for information, documents, or other requirements of the procedures. Fiona, did you want to talk about that in the context of a mediator and what it might be like for them?
Yeah, so I think in the past, sometimes with mediation, particularly property, was sort of an optional. Now it's really with the genuine step certificate, you need to be making sure that you've made a genuine effort, including participation in dispute resolution. And I know from our family dispute resolution online group, there's a lot of discussion around how is this going to impact the work of mediators and FDRPs. I think it's a good thing that there's a big emphasis on dispute resolution and compliance, and really front-ending the work of the family law profession to try and resolve things as quickly as possible and prior to the commencement of court proceedings. Because as we know, a lot of matters do resolve at some point along the case management pathway, but the sooner the better for both the clients, the lawyers, and of course the court, who's really aiming to resolve all matters within 12 months moving forward. So I guess front-ending things is the aim to do that. And compliance, I think the focus on compliance, the penalties involved, including costs orders against lawyers, which some of us lawyers can get a bit concerned about, but those have always been in the rules, haven't they, Therese? Cost orders against lawyers. So we shouldn't be too concerned about them, and particularly if we're up to date with the FCFCOA and engaging in the pre-action procedures and dispute resolution as we are required to with our clients, then I think it's nothing we should be overly concerned about.
No, I don't think so. And I think the great thing that is potentially going to come out of this is that there'll be a lot more focus on early intervention dispute resolution, and it'd be great to hear from some of the mediators as to whether or not they've seen an increase in mediations prior to the commencement of court proceedings. Great,
thank you. I'll move on to the next slide. Therese?
Yes, we've just covered that one. So if you move to disclosure, yeah. So the general duty of disclosure is found in Rule 6.01. It commences at the start of the proceedings and continues until proceedings are finalised. But people must note that they're also expected to comply with the duty of disclosure when complying with pre-action procedures. That's really, really important. And if you look at all of the brochures in relation to pre-action procedure, they all set out the objectives of the pre-action procedures are to encourage early and full disclosure through the exchange of information and documents about relevant issues. Now, if we look at the Rule 6.03, duty of disclosure applies to each document that is or has been in the possession or control of the party disclosing the document, and more importantly is relevant to an issue in the proceedings. So there's this real emphasis on what are the significant issues in dispute and what is the evidence that's required to support that issue or to assist to resolve that issue. As Fiona mentioned before, parties do need to file an undertaking as to disclosure, and that's found in Rule 6.02. In the event that they provide any misleading or false information in that undertaking, it is an offence, and it may attract 50 penalty units, which is not something anybody wants to have to pay. And also, if there's a breach of that undertaking during the course of the proceedings, that can be found to be contempt of court. So some new things in relation to duty of disclosure. In relation to parenting, which can be found at Rule 6.05, these are new things that are being asked for in parenting proceedings, and they include the criminal records of a party, documents filed in an intervention order proceedings concerning a party, medical reports about a child or party, and school reports. Again, really important, Rule 2.10, must file a copy of any family violence order which affects the child or a member of the child's family. In relation to property, the general duty of disclosure in relation to property set out in Rule 6.06. I'm not going to go through all of those because they are essentially the same as previously, but it's very important to note that they're in Rule 2.10. You must file a copy of any family violence order affecting the party.
So just to summarise that, Therese, it's really providing full, frank and timely disclosure of everything relevant to the proceedings that's in the possession or control of the party. And parenting, there's now under Rule 6.05 some specific documents that should be disclosed. And that should be for dispute resolution prior to the commencement of proceedings as well, I'm assuming.
Yes. I mean, I assume that some of that information, like the criminal records, are unlikely to be able to be obtained prior to court proceedings because you may require a subpoena. But documents in relation to an intervention order, like the application, like witness statements and that sort of thing, that generally speaking you can obtain copies of, absolutely obtain prior to the commencement of court proceedings.
And family violence orders, it's not just between the parties, but anyone. So if there was a family violence order or an AVO in regards to a work colleague against one of the parties, that would need to be disclosed as well.
Yes, and any other party to the proceedings as well, whether or not they are a parent to the subject children or not.
And as you said, an undertaking disclosure now is an offence if you misleading or falsely sign that undertaking as disclosure. So it's really something that we need to be, as family law professionals, clearly advising clients on and their obligations for full, frank and timely disclosure. Because what are the consequences, Therese, of non-compliance?
Yeah. So just before we get to the consequences, any document that we do obtain during the course of disclosure must be used only for the purposes of the proceedings. This is really important, and that's set out in Rule 6.04. There is also a mechanism to seek disclosure that's set out in Rule 6.09, and that is that after the allocation of the first court date, a party can request a list of documents by written notice. And within 21 days, the disclosing party must serve the documents to which the duty of disclosure applies, or explain why, if there are any documents that are no longer in the disclosing party's possession or control, with a brief statement about the circumstances in which those documents left their control. And also any documents which privilege from production is claimed, and you can see Rule 6.15 to see what you need to do if there is an issue in relation to privilege. And if for example, after the fact, any documents that are sought come into the possession or control, they must be provided within 7 days after it's located or come into the party's possession or control. So in accordance with Rule 6.13 or 6.14, you can either seek a copy of the document or request that it is made available for inspection. And yes, we'll get to the consequences of non-disclosure now, and that is at 6.17. So if a party does not disclose a document, the party must not offer the document or present evidence of its contents at a hearing or trial without the other party's consent or court's permission. They may be guilty of contempt for not disclosing the document and may be ordered to pay costs. And then the court may stay or dismiss all or part of the party's case. And this really goes back to what the court's trying to avoid. They do not want parties to be surprised by information, at a hearing. They want people to understand the case that's before them, the case that the other party's seeking, and the evidence that is being sought to be relied upon.
And that's really always been the case, to show your hand before you get to the hearing. But I think that the rules make it really clear as to the importance of disclosure and the consequences for non-compliance with that disclosure. Jacqueline asked the question, would this also apply to the new partner of a parent to the child? And I'm assuming that's relating to the family violence order.
Yeah.
If there was a new partner, if they weren't a party to the proceedings, would you still need to disclose that?
The rule itself, if we go to it, sorry, just bear with me. If we go back and we click on 6.0, rule 2.0.
Yeah.
It says any family violence order affecting the child or a member of the child's family. And then also in relation to financials, it's a order affecting the party. Now, I think in the context of parenting proceedings, though, if this is a person that is going to, hold a significant position in those children's life, absolutely, I think it's relevant for the purposes of the court proceedings.
Mm-hmm.
I think especially if it's an AVO that's, potentially between a party and their new partner, because it goes back to is there any sort of exposure to family violence, and what's that effect on their children, and how do we mitigate risk by addressing those issues?
Okay, thank you, Therese. So what we might do now is move on briefly to look at how family property can assist in providing that mandatory information that we have to provide to the clients, and how it assists with disclosure obligations as to both parenting and financial. So over to you, Tim.
Thank you. I'll just share my screen and just take you through a couple of things so you can see how you could potentially handle a few of these requirements and mandatory steps in your workflow. So we're obviously going to show you how this can be done in family property. And like always, pop questions into the Q&A or the chat if you want to see something in a bit more detail or ask questions about how it works. So the first thing that I'd like to cover off is the mandatory information. So that court information that you need to provide to clients to inform them so that they understand. So the first thing I do want to highlight really quickly is if I click on this Create a Matter button here, in family property, you do have the ability now to conduct property matters, parenting matters, or parenting and property matters. So when you're setting up the matter, you can select that simply by clicking the applicable option here. You can also include some current situation questions in the questionnaire as well, if you would like to cover off some screening related questions in the questionnaire intake as well. And also, so that you're aware, you can invite your client to complete the intake questionnaire. And that's as easy as ticking this box and putting in their email address. But one thing that I did want to highlight here is that you can tailor the experience based on their situation. So as you can see here, there's a number of tick boxes showing you all the steps in the questionnaire. And some of these are related to to property, financial questions, and some are related to parenting. And so you can tick and untick these boxes to provide a tailored experience for every single one of your clients. You can also choose to include the client portal step, which is where you can work with your clients to collect those documents that are required as part of their duty of disclosure. So it's really quite simple to set up a matter. Well, once you've done that, so for instance, if I wanted to invite my client, I would put in their email address there and click save. They would receive an automated email allowing them to get started with a questionnaire. But let's assume now that I am the client and I've clicked on that link and I'm now going to get started on the intake questionnaire in family property. So the first thing that I'll see here is a nice little welcome message explaining to me in really easy to understand language around what this important information is about, and it's part of the court process. And you can see here that all the links have been compiled for you, ready to go across property and parenting matters. The good thing about using something like family property is we keep our finger on the pulse. So if the links change, the locations change, they add more content, we'll automatically update that. So you don't need to worry about maintaining links in emails or anything like that. And so once as a client, I've reviewed this, I can click on this and review it on the court's website. I click let's start. So really quickly, there's a lot of information here. I won't spend too much time going through the actual questions, but you can see here I've got a scenario with Alexander Miller and Sophia Miller here. And there's, just to give you an idea, you've got some questions that cover general related information like children and relationship and living arrangements, property related questions that cover things like assets, super, contributions, future needs, factors, current situation, so things like current proceedings and orders, and questions related to family violence and even how you're coping, so you can get a good assessment around those kind of screening questions. And then finally, parenting arrangements, and they're broken down per child, so you can get a really good understanding of what the parenting arrangements look like for each of the children involved in the relationship. Before I move on, Fiona or Therese, do you have any comments?
So in regards to the questionnaire, as Tim said, it's flexible as to which parts of the questionnaire you ask your client to complete. It's written in plain English. It can be completed by them 24/7 over a number of sittings. It also, and Therese is working very hard on this, we're trying to map all the fields in the questionnaire to the relevant court form. So the benefit of completing the questionnaire is it then auto-populates and makes recommendations in the client portal. It then auto-populates into the dashboard, which we'll show you later, and then it auto-populates into the relevant FCFCOA forms. So by putting that information in once, and hopefully correctly, if your client's putting in their details, or then you're assisting them complete that, then that will save you the time and the manual effort of having to repeat ongoing when you're completing these relevant forms.
So once your client or you have completed the questionnaire, you can then submit it. Just to let you know as well, you can enable additional options in that submission window you just saw there. For instance, you can provide information around your cost agreement and other terms and conditions, and allow your client to actually tick a box and say they agree prior to submitting the questionnaire. So it's very flexible in terms of the way that it can work within your office processes. Now, what Family Property then does is it analyzes all of the information put into that questionnaire around assets, liabilities, super, contributions, future needs, income, all of it. And obviously, a really important component to that is children and parenting, and then lists the items on the screen that require further documentation as per duty of disclosure. So, for instance, 30 Barker Street, Sydney is a real estate property, so it's making recommendations that appraisal, online valuation, or a formal valuation needs to be done, and council rates uploaded, investment documentations for shares in Telstra, registration paper in terms of a vehicle here, and so on and so forth. So you can see that these recommendations here are really clearly spelled out for your client, and they're based on the family court rules. So we've adapted them and put them here as a little checklist that they can work their way through, getting that information, uploading it, and then ticking off the items as they go. You can also turn on additional task-based recommendations to actually give some suggestions to your clients around the kinds of locations that they can go to get some of this information. So, for instance, go and do an InfoTrack lookup, a Redbook search, ASX share search, and things like that. If you would prefer your clients clients to actually self-service and do a little bit more of that information gathering. But one thing that I do want to highlight down here is under children and parenting. So you can see here that it is making those new recommendations around school reports, medical reports, verification of identity and domestic violence orders. And so you can see here that it clearly spells out what those requirements are. And then if any of those are applicable, all the person needs to do is click attach, select a file to attach from their computer, click browse, and then they can then upload any relevant documents by finding the file and clicking attach, and that's it. And the great thing about this is then this is attached against the children and parenting section in Family Property, as is if you uploaded a document in relation to the family home or the vehicle. These documents will be automatically attached against the right item in your balance sheet. Any questions or comments on that, Fiona or Therese?
There is a question just related back to the questionnaire with regards to perhaps showcasing or getting them to review your cost agreement. There is an optional question that you can ask at the end that has a link to your cost agreement, a link to maybe join your mailing list, or a link to add in who you were referred by, etc. Did you want to show that pop up, Tim, or would we show that later?
Yeah, I did mention that. We can show that later.
Okay, so hopefully that answers that question, Kirsten. And just in regards to the disclosure, as you've seen there, we make recommendations around both the financial and the parenting, but you can also add customized recommendations or ask your clients to upload additional documents, because remember, under the rules, it's everything relevant. So this is sort of the mandatory, but there might be more. So we can show you that at a later stage as to how you can ask for them to upload additional documents. Also here in the actions button, if you want to take them through briefly that, Tim.
Sure. So you can, obviously, this is a great way of guiding your clients through their duty of disclosure and getting the information from them. But they can also download all of the documents that they've uploaded as a zip package, which is a single file that contains lots of files. So your clients can obviously get their information out of Family Property really quickly and easily. They can also generate a document index as well, which is an Excel spreadsheet, which will collate all of the information in relation to each document into a master list, which is very helpful. Of course, you can also access all of this through Family Property too. And finally, they can get access to a shareable link of these documents if they do want to provide access to, say, their accountant or another professional for further review of these documents. So making Family Property really a collaborative central hub for the disclosure information in a secure way.
Excellent. Thank you, Tim. So we might move on now back to the forms, the all-important forms. So I'll just share my screen. And I've got another pop-up poll question as well. So I'll launch that. But over to you, Therese.
Thanks, Fiona. Yep, so we're going to be going through the documents that you require when you're initiating or filing documents. This is a summary, but we're going to be going through each document one by one. Just to go through this particular screen, we have the documents, a link to the document, the rules, and then the reference to the parent practice direction, and then the financial practice direction as well. And then I've also just put in some notes there about when documents must be filed, but we will be going through that on the next page. Just be mindful that there may be other documents that might be required depending on the orders that you seek. So you really should read the relevant practice direction for each type of proceedings. And again, see Rule 4.012 for any exemptions, including on the basis of risk or urgency. Fiona, if you can just move to the next slide. So the initiating application, this is essentially used for seeking final orders. You can only seek interim or interlocutory orders if you're also seeking final orders. The rule, Rule 2.01, there is a table in that section which sets out all the different types of applications. I'm not going to go to it right now, but there are about there are multiple applications, as you can see. There are applications for enforcement, applications for divorce, contravention, contempt review, and an application in a proceeding. And just noting that there is a rule that there is a maximum of 2 without leave. In relation to enforcement, you can now use that instead of an application for contravention, and that's really for if you want to use it to make up time as opposed to applying for a contravention. Now, in terms of service of the initiating application, that must be filed as soon as possible after the date of filing. And a party who has filed an application or response may amend the application or response in compliance with the time limitations. If you can move on to the next slide, Fiona. Yeah, thank you. So when filing a response, it must be filed in the approved form when you're seeking to consent to an order sought by an applicant, ask the court to make another order, ask the court to dismiss the application, or ask for orders in a matter other than as set out in the application. So that might be that the applicant has filed some parenting proceedings, but you've now responded with both parenting and financial proceedings. That response, this is a different order in relation to service than previously. It must be filed and served within 28 days after service of the application to which it relates. If the party doesn't contest any of the orders sought and will submit to the orders that the court may make in relation to that application, in accordance with Rule 0.22, you can file a submitting notice, and there is a link to that document on this slide. In relation to replying, Rule 2.21 sets out that a reply must be filed if the respondent seeks orders in a cause of action other than a cause of action referred to in the application, and the applicant seeks to oppose the order sought or is seeking different orders. And again, that is if you originally lodged an initiating application in relation to parenting, and now you need to respond in relation to property as well. And it must be served 14 days after filing. If we can move on to the next slide, Fiona.
So what I'm hearing from you, just in summary, is the initiating applications similar to what we used to do. But with the time frames, what I'm hearing is this 28 days, the response has to be filed after service. I think it was 14 days prior to the court event in the old rules. So that's important to be aware of. It's 28 days after service, and I think that reflects, sometimes it takes documents a bit of time to come back from the court. So be aware of that time limit and the response, but also the submitting notice and a reply. I know sometimes people seek parenting orders only, and the respondent seeks parenting and financial. So the reply is filed by the applicant in response to those financial orders if they weren't added initially. Genuine step certificate, Therese?
Yes. So in accordance with Rule 4.01, applicants and respondents must file a genuine step certificate with an application or a response certifying that they have complied with the pre-action procedures and taken genuine steps to resolve the dispute, or set out the basis of any claim for exemption. So that's the exemptions in relation to risk or urgency. An affidavit is now only required where interim orders are sought, or a respondent opposes any interim order sought, whether you're seeking an exemption on the basis of urgency. If you are seeking on the basis of urgency, you must complete a covering letter, and you can look at the Parenting Practice Direction 2.9 to 2.10 to look at what you need to address in that letter. And then again, if ex parte orders are sought, and you should be looking at Rule 5.11 to look at all of the things that you need to address in relation to that as well. So yes, a person must not apply for an application for interlocutory orders unless there is an application for final orders that is current in the proceedings, or the application includes an application for final orders. And in that, any affidavit, prior to seeking an interlocutory order, a party must set out in that affidavit that they have made a genuine and reasonable attempt to settle. Now, when you're addressing that in the affidavit, it is really important to remember, though, that you don't disclose any without prejudice offers in this context. So you should be looking at Rule 4.07 in relation to that particular paragraph.
And just with this genuine steps certificate, I know a lot of us mediators were hoping it would be the equivalent of a Section 60I certificate for property matters. Is that the case, or is it broader, this genuine steps certificate? Do they have to go to dispute resolution or family dispute resolution for property cases? Or what are the requirements there? What's different to the Section 60I for parenting?
In relation to obviously the Section 60I is specifically in relation to parenting, but there is absolutely an emphasis on parties attempting to attend dispute resolution, whether it is either for parenting or property proceedings. Yes, and if you look at the genuine step certificate itself, it also, you need to look at and tick off whether you've made attempts to attend dispute resolution. So if we just go to Part A, so you're essentially ticking off those pre-action procedures that we talked about before. So providing a copy of those pre-action procedures, making inquiries about dispute resolution, inviting them, participating, and again, if we go further down, we can look at Part 4, which sets out what you'd be seeking an exemption for, and that is again around family violence and urgency, any prejudice that might happen, and so on and so forth. And so in this genuine step certificate, there are separate sections that need to be filled out by the applicant and the respondent, but they're very similar.
And that's signed by the lawyer or the party. It's not signed by the dispute resolution practitioner.
That's correct. And I think the only other thing to mention is that, and when we have a look at these, the initiating application and the response both quite clearly set out on the top of those documents that a genuine step certificate must be filed with the initiating application or the response. Mm-hmm.
And in regards to affidavit, we know in the Federal Circuit Court, the old Federal Circuit Court, an affidavit was filed at the commencement of proceedings. That's no longer the case. It's only now, like the old family court system, it's only now where interim orders are sought, urgency or ex parte orders, and there's a limit to those affidavits. We can't put a whole story in hundreds of pages. What's the limit there, Therese?
Yes, so we are going to be addressing that in a moment, but on a short-term basis, sorry, just bear with me.
I've got that. It's 10 pages, I think.
So Division 1 is Division 1, which is 25 pages and 10 annexures, and Division 2 is 10 pages and 5 annexures.
Thank you. So did you want to demo now, or do you want to go into the parenting and financial side first?
I think it's okay for us to demonstrate that now. Yeah. So
over to you, Tim. And if anyone's got any questions in the meantime, feel free to add them into the Q&A, particularly around the genuine steps certificate, initiating application and response. We'd love your feedback on how you're finding these forms through the poll, but also in Q&A if you've got any questions. Over to you, Tim.
Great. Let me just share my screen again. There we go. Can you see that okay?
Yes.
Yep. So this is just a questionnaire I had up moments ago. I did want to answer Kirsten's question, I believe. You can add at the end here. So this is the final step in the questionnaire. And if I click submit, you can optionally allow the person to answer the question of where did they hear about you and your service, which is always a great marketing indicator. So you can ask that question optionally at the end. You can also then present information around your cost agreement or any other terms and conditions that you might want to present to the person on submission, and they will need to tick this box in order to progress forward. And another optional question you can ask is if they would like to join your mailing list or receive any additional communication from you or your firm. So I did just want to answer that question really quickly. I hope that does answer that for you. Please let me know if I can provide any more information there.
And that maybe answers Jessica's question as well. You can optionally add in all those mandatory information links into that box at the end and make sure that they've had an opportunity to read them again and sign off that they've read and received those.
Correct. So let's move on now and have a look at the initiating application and response and see how the information that we've collected so far flows into those court forms and how you can also enter in any other additional information that you might have. So once you're finished with the questionnaire and you've submitted it, you've reviewed the information your clients put in and you've submitted it, you can then convert that information into Word documents in the form of a report and a balance sheet document, and also download any attachments that might have been uploaded in that disclosure step. But what you can do now is very easily and quickly start to put together that initial, I guess, position in relation to what you would like to see appear in the document. And so that's all I'm doing here at the moment is I'm just next each item in the balance sheet, which has been automatically compiled from the information in the questionnaire. I'm just indicating what we would like to do, the action we would like to take with each item. So for instance, the family home, we would like to sell it and divide the proceeds, let's say 50-50. Alexander has some shares in Telstra and the BMW vehicle and antique stamp and coin collection, whereas Sophia has an investment in Castle Hill, a unit, and a Toyota Camry. So we might just indicate that they can both retain their relevant assets. We may discharge the mortgage, but Alexander has a personal credit card debt which he'll retain, and they might want to retain their own super funds. So visually, I can start to put together what I want to go have put into the court forms. Like, for instance, the initiating application response by just visually putting that together on the screen there. So now what we might do is also have a look at the parenting side of things. So if I click on parenting, you'll see that the two children here, their information has been captured in the questionnaire are here, and I can click on either of the children and review the information that's been entered. But I can also click on arrangements and start to put together the parenting arrangements. So this could be the general schedule, might look like alternating for this family, alternating weekends, where Alexander has the children on alternating weekends from a Friday to a Sunday period every second weekend in a fortnight. So I can quickly and easily put this information together, defining things like school holidays as well, where they may want to share half the period starting with Alexander in 2021 and then alternating each year on and off. You can put in changeover times as well, so you can get to that level of detail if you need to. And then finally, you can also do things like special periods, Easter, Christmas, Mother's Day, Father's Day, birthdays. You can remove these if they're not applicable, or you can add other special occasions as relevant for the family unit. And then that will then be plotted into a calendar for you. So you can see here the every second weekend on being automatically calculated and put onto a calendar. So I can see how those arrangements play out day by day throughout a calendar for about the next 2 to 3 years. So we can see here in New South Wales, at least, we're starting term 4 today. So you can quickly and easily start arranging the information around your balance sheet and your parenting arrangements. And then when you're ready, you can click over to our smart forms. So for instance, let's have a look at the initiating application. And you'll see here that this is a digital online form version of the courts form. You can see it's hopefully a lot easier to fill in and provide the information. But the great thing about this is all of the information that you've already entered around the parties and children and assets and liabilities and income and expenses and all of that, where we can map that into the form. We've already done that hard work. So all of that information will automatically flow through into the form for you. You don't need to double enter it. All you need to do is confirm things like what kind of orders you are looking for, and then confirm any other details that you might need to enter. As you can see here, some of the information may have already been populated and other information you can enter in on the spot. And then when you're ready, you can just click the download button, and then this will then obviously generate the court form for you, which I'm going to bring up really, really quickly. just so that you can have a look. So this is the new court form, and you can see all of the information goes in, the right boxes are ticked based on the information. The good thing about this, though, is that it will automatically put in generated legal orders around parenting. So you can see the children live with Sophia, except when they're to live with Alexander, and they're going to, alternate weekends and holiday periods and special occasions. So those orders have already gone in, and same with property as well. So the parties will do and sign everything required to sell 30 Barker Street. So the detailed orders have been automatically generated for you and inserted into the right part of the document, hopefully saving you a lot of time. And then you've got Part B onwards here will be completed with the information that you've put in Family Property and in the smart form as well. Now, this is a Microsoft Word document, so it is designed for you to review and fine tune as needed. You can just continue to work away in Microsoft Word, as you're probably already used to doing.
I think the other important thing to mention, Tim, is that these are unlocked versions. So I think a lot of people were struggling with the versions on the court website because they were so locked in, whereas these are the unlocked versions. And really the only major changes on here are references to genuine steps and adding in things like email, because that is now accepted as a form of ordinary service.
Yep. Quick questions on that, Tim. The grey boxes there, that's an FCFCOA court formatting issue, isn't it? Some of these forms are a bit difficult to work with.
Yeah, so the form as it's designed in Microsoft Word and released by the court does have, yes, these little grey boxes, which are designed to be text boxes. So, if you're working Microsoft Word, you can type in your answer directly into Microsoft Word. Yeah, unfortunately, that they work differently on different computers and different versions of Microsoft Word, and sometimes they look grey, sometimes they look white. Unfortunately, yeah, it's not the best way of collecting data, unfortunately, Microsoft Word, but it's what we've got to work with. So what you will notice, though, is that the Family Property will obviously pre-populate all of the grey boxes and the tick boxes for you based on the information that you've entered in through the smart form and the intake questionnaire to date.
And we do the same for the response, I'm assuming?
Yeah, that's right. Yep. So depending on what you need to submit, you will find the initiating application and response to initiating application, and you'll see the response. It's really the same kind of workflow for you. You enter in the information in Family Property. You'll see a smart form to confirm that information and fill in anything additional, and then you click the download button to get your document.
Tim, can you just go to the children section for me for a moment?
In where, sorry?
In the response. So there's
Yeah.
Actually, yeah, sorry, I think it was in the initial application. That's okay. There's a new feature because in the questionnaire you can add children that are not only subject to the proceedings, but also children that live with you. We've added a new feature in the initial application where you can indicate whether or not the arrangements are in dispute, so that only the children that are relevant to the court proceedings will appear in the court forms. And that's also reflected in the parenting tab as well. Yeah, and we've received some feedback about the wording in relation to that. And so we're going to be making some minor changes to that as well.
Great. So I'll just share our screen again. Tim, you've finished that demo. We just had a couple of questions again around the genuine steps certificate. One was, do you still need to file a Section 60I certificate as well as the genuine steps certificate if it's a parenting matter? Yes, definitely. And we're coming to that in a moment around parenting, but you will need to file both a Section 60I certificate as well as the genuine steps certificate. The second question was around would, say, standard negotiations between lawyers or even a roundtable settlement conference be sufficient when filing the genuine steps certificate? On our reading of things, it talks about dispute resolution services, and then it gives a list of dispute resolution, including services by private practitioners, family relationship centres or other community organisations. And it does specifically say made inquiries, participated in dispute resolution. So our reading of it is that that we don't believe that standard negotiations would be sufficient, although perhaps if it's arbitration or collaborative practice, I know collaborative practice that may be sufficient, but that's something that we'll have to look into further. I'll come back now to financial matters, Therese.
That's right. So these are the forms that are specifically required for financial matters. So in accordance with Rule 6.06, a financial statement and a financial questionnaire must be filed. The financial statement can have an affidavit only if a financial statement won't fully discharge your duty to make full and frank disclosure. The financial questionnaire is a new form. And in that form, parties must provide a chronology of relevant dates and outline the issues relevant to Section 79, both pre, during and post cohabitation, including the future needs of the party. We're in the process of building that document, and what we're planning on doing is in the questionnaire itself, there's a section for contributions and for future needs, and we're going to be taking that information from the questionnaire and populating it into that smart form to facilitate you filling in that financial questionnaire. In accordance with Rule 1.12, you must serve a written notice on each person referred to in Section 7910 or 90 SM10. And if you are seeking a flagging or splitting order, you must immediately, after filing an application, response or reply, serve the trustees of the eligible super fund. In relation to any freezing or search order, which have been renamed, must be filed. An affidavit in relation to that must be filed, and you can look at Rule 5.23 and 5.19 with respect to those applications in relation to what you need to address. And again, there's just a reminder that you must file a copy of any family violence order affecting the party. If we can move on to the next slide. So these are all the documents that must be filed in relation to parenting matters other than the other documents that we've already reviewed, and that is the parenting questionnaire. This again is a new form. It must be filed with an application for final orders or a response. It's got about 58 questions, and it covers everything from current and future parenting arrangements, safety issues, housing and supervision, childcare, schooling, and financial support. And again, we're working on building that document in and propagating any of the relevant questions in the family property intake into that parenting questionnaire to facilitate filling out that document. The next form is the notice of risk. This is in accordance with Rule 204, really important to note. It must be filed at the commencement of proceedings. If there are any new facts or circumstances that are raised during the course of the proceedings, you must file a notice of risk. So I think, previously most parties would only ever file sort of one notice of risk at any given time, but this is absolutely emphasising the importance of if there are any new facts or circumstances, they must again file a new notice of risk. And lastly, we've got the... I found this on the web. Excuse me, the Section 60I certificate or an affidavit non-filing. So the affidavit non-filing, again, that's used when there's you're seeking exemptions on the basis of urgency or risk. But if you are seeking interlocutory orders at the same time, generally speaking, you don't need to file that affidavit non-filing FTR certificate, only if you're seeking final orders. And again, really important to note, in accordance with Rule 2.10, must file a copy of any family violence order affecting the child or a member of the child's family.
So just to summarise what we're seeing in financial matters, in addition to the initiating application, genuine steps certificate, affidavit if needed, and the undertaking as to disclosure, yes. So that's whether it's parenting or property. For financial matters specifically, we've got the financial statement that we're accustomed to as family lawyers, which Tim will be briefly demonstrating in a moment because we've updated that form. There's also now a financial questionnaire, which used to do later in the proceedings, which now is upfront, completion of that financial questionnaire in addition to the financial statement. Again, we'll be populating that, hoping to launch that soon. And then then for parenting, the notice of risk, there was a different form in the family court to the Federal Circuit Court, but now we're seeing the notice of risk has to be filed in the court, not only at the commencement, but during the course of the proceedings if things change, as well as this quite lengthy parenting questionnaire. But I guess it puts all the information before the court up front in a way that's perhaps instead of an affidavit, because no affidavit's needed unless interim orders are sought. And then, as we said earlier, Section 60I certificate required. So demonstration, Tim, on the financial statement, very briefly.
Just take myself off mute. Yep, absolutely. Financial statement. Let's have a very quick look at that. I'm just going to share my screen. I do note there was a question around the grey boxes. I was just reading the comments while we continued on there. And just a tip. Now, the caveat is this works for me in my version of Word, and I use a Mac. It may not work for you, but when I export out any of these court forms to PDF from Word directly, the grey boxes do disappear, and I'm just left with the information. So there was a question of, can we get rid of the grey boxes? Try exporting them to PDF just before you're ready to submit them. And hopefully, like my version, you'll find that the grey boxes disappear and the information's left. So I hope that helps you in relation to the grey boxes. Okay, so let's have a really quick look at the financial statement. So like everything in family property, when it comes to a court form, there's probably a smart form that we've built for it. So in this case, I'm going to hit back to more and smart forms. And what you'll find here is the financial statement and the financial statement part N. We've actually broken these into two separate smart forms because the feedback that we got was that quite often you may want to get your client to work on just part N, their expenses independently to the financial statement as you compiling that. So now we've actually built two forms. So you can actually be working on those two, the whole form versus part N, either together or separately. One other thing that I did want to show you is that you can also, for any of these smart forms, get a shareable link. So you just click on the three dots here, let's say next to the financial statement, and click on Get Shareable Link. And what that'll do is that will give you a link that you can copy, and you can go, I'm just going to pretend now that I'm the client, and I will open that up, and then they will just get a nice, clean, simple version of the smart form. So in this case, it's the financial smart form that they can then review the information that you may have put in so far, and they can continue to populate the information in directly into the screen. And then when they submit this information, you'll receive an email letting you know that, so that that's your cue to then jump in and have a look at it. So you can work quite collaboratively in family property, collecting the information that you need for these court forms using the shareable links. Now, you might notice in this smart form, all of the assets and income and expenses and liabilities and everything have already been auto calculated for you based on what's in the balance sheet, which I showed you in the demo earlier. So you don't need to bring out your calculator. It will do all of the calculations around your balance sheet for you and then put in those final figures into the court form. So I did just want to show you how you can engage and work with your clients to collect this information when it comes to preparing these court forms. But of course, you yourself can click on these and fill in the same court form, same smart form online. And then just like the other ones, when you're ready, you just click the download button to then download a generated Word version compiled with all of the information obviously entered so far in that court form there. So Fiona and Therese, any comments that you want to make in regards to the smart forms and financial statement? Shareable?
Yeah, I think so. We're updating the links to the new rules and everything, and that will be released shortly. I think the only other thing is, whilst if you update the Word document, it doesn't update family property, which was a question that somebody asked. If you are updating a particular section within the smart form itself, if there's the same question in the questionnaire or in the balance sheet, that answer will populate back. So you don't have different information across the platform. It's all synced to the same thing.
Yep. And the part N, which I've just brought up here so you can have a look at that, it is an auto-calculating table. So as you are entering in expenditure line items for these things, it will automatically give you a line item total and a grand total, when those numbers will then flow into the court form itself. Again, helping you not to need a calculator, so much.
screen. I'll share my screen again. And Therese, did you want to discuss, I guess we've done pre-action procedures, we've filed, and briefly discuss these two court events?
What I want
and the
to
pathway?
just focus on the interim hearing page, because I think we're sort of running out of time, and we want to be able to cover dispute resolution. So if you go to the next page, Fiona, what we've done here is we've just really tried to pull out the rules that you need to know when you're going to be running an interim hearing. So there is a rule 4.03 that before you file an application seeking an interlocutory order, that you must make a genuine attempt to resolve. So again, that's in the context of pre-action procedure, but then also in the context of court proceedings themselves, and also remembering that there is a limit of 2, so use them wisely. The interim hearing itself has a 2-hour limit. Really think about being proactive, and if you need to negotiate, making sure you get to court early, so that you're not wasting any of that time. Again, with the affidavits, Division 1, 25 pages, 10 annexures, Division 2, 10 pages, 5 annexures. These, obviously, some of these rules can be varied by the court, but you need to talk to the court about why that you may need to amend that order when seeking directions about filing. A really important rule is 1 affidavit by each party, and especially in relation to the witness, the evidence must be relevant and cannot be given by a party. So you really need to think about your witnesses and why you're asking them to provide evidence before the court. And unless otherwise directed, an application and other documents filed must not be served less than 3 days before the day fixed for the interlocutory application. So again, it's just providing that notice to parties. The central practice direction at 5.1a sets out that a minute of order and a case outline in approved form must be forwarded to the associate or the senior judicial registrar before the interim hearing. I think I missed that out. It was 2 days before the interim hearing. And if the interim hearing is going to be heard on the papers, then you must file and serve a list of documents and submissions at least 2 days before the hearing. If you are seeking an administrative adjournment, it must be sought by consent and be in writing, and send it to the registry manager no later than 12 noon on the day fixed for hearing. So that's different. I mean, I think previously we used to send that request to either the associate in chambers or to the registrar. You are now sending that to the registry manager, and you must set out why the adjournment is appropriate, and ask for a date for it to be postponed. Now, just in general, I thought that these were some really important rules that you need to be aware of. Just in terms of the formal requirements for documents, there is a number of formal requirements in there, but for example, they're seeking that documents are 12 point in size, Times New Roman or equivalent. And so that's for things like the information that you've put in your case outline or submissions. Rule 2.32 shows the portal for deadline for filing. So that's 4:30 p.m. ACT time. So just be mindful of that when you're, because otherwise it will be counted as being filed the next day. So you may not be in compliance with the directions for filing. Yeah, and so there's a general rule here at 2.31 that unless otherwise directed, an application and other documents filed must not be served less than 7 days before the day fixed for the hearing of any other application than an interim application. So it's giving you a little, a longer period of time between the day that you need to file and the hearing. And really importantly, rule 1.33 to 1.34, if a step is taken after the time specified, the step is of no effect. So obviously that can have quite significant consequences if you do not file your response in time. The other party could seek that the matter proceed undefended. So it's really, really important that if you have not filed, or you know that you're not going to file in time, that you take those steps to ask for different directions in those circumstances. Otherwise, you're going to be in a bit of trouble. And obviously there are some pretty significant consequences, like the court can dismiss all or part of the proceedings, set aside a step taken or an order made, determine the proceedings as if it were undefended, like I've just mentioned, order costs, prohibit the party from taking a further step until the occurrence of a specified event, and make any other order that they consider necessary.
And I think as a family lawyer, I think the timeframes and compliance with those, I think in the past were perhaps more of a guideline. People treated them a bit more like a guideline. Now it's very strict timetable as to compliance and seeking permission if you don't think you can comply. And I think coming back to dispute resolution, which is the thing we covered today, it also flows through, of course, there's an emphasis on dispute resolution, but also compliance with time frames and directions that the family dispute resolution practitioner makes are really important as well. So this is dispute resolution after the commencement of proceedings, not to be confused with pre-action. This is after, so there's greater preparation, more rules, etc. And the central practice direction, again, is something that us as family lawyers and family mediators should become familiar with, because it sets out within 5 months of the commencement of proceedings, parties are required to participate in dispute resolution in both parenting and financial, unless exceptional circumstances apply. And that's often going to be at that first court event. The parties are going to be referred back out to either external dispute resolution or internal dispute resolution. And you really need to get instructions on the client's financial capacity to afford private dispute resolution, because it's likely, if they can afford it, external dispute resolution, including mediation, family dispute resolution, or arbitration by consent. Whereas the court-based dispute resolution, we've of course got the conciliation conference, judicial settlement conferences, or the FDR conferences under section 13C1B, with a judicial registrar who's also an FDRP, and a court child expert, which is the old family counsellor for parenting mediation, FDR. Remember, all dispute resolution is confidential, offers are without prejudice, parties are to participate in good faith negotiations and make a genuine effort to attend. And if a dispute resolution event does not occur because of parties' non-attendance or non-compliance with directions, then there may be consequences again. So important for you to be aware of that. As far as preparation, there's some specific guidelines in the central practice direction as to the preparation required, which is 7 days prior to the mediation. I know as a mediator, often it's the day before, the day of sometimes, but we really as mediators need to be pushing back and saying, no, the central practice direction says 7 days prior to the mediation, and this is what we require as family dispute resolution practitioners, unless there's an agreement between everyone, so the FDRP, parties, lawyers, or the court directs otherwise, they need to comply with this preparation 7 days prior, which is all relevant court documents in the proceedings, expert reports, any documents exchanged between the parties where there are issues in dispute with relevant passages highlighted. So I've had one recently. I got them to highlight the specific transactions in the bank statements that were relevant to an important issue in dispute. A minute of the orders that are sought, and obviously Family Property can assist with parenting, draft parenting orders, draft property orders. The confidential case outline document, which Tim will showcase shortly. If it's a financial case, particulars of any financial resource, so if there's an interest in a trust, likely in inheritance, compensation payment, that should be disclosed, as well as a valuation or market appraisal, only where there's the issue in dispute. Most recent super statement and super splitting order procedural fairness has to be obtained before the dispute resolution event. As Therese said, current or previous family violence orders, so that's really important, as well as a certificate of dispute resolution, which is a certificate that us as mediators, family dispute resolution practitioners need to sign to say whether the parties have attended, made a genuine effort and complied with the cost notification, which unfortunately we don't have time to go into costs very much today, but that is an important part of that. And this is what's signed by the family dispute resolution practitioner or mediator. any other documents reasonably requested by the mediator as well. So all of those documents must be provided 7 days prior to the parties and the FDRP. In addition to that, of course, we've got the obligation to provide full and frank disclosure under the rules, any other reasonable requests, and costs. So there's a few things with regards to costs, not only exchange between the parties, but provided to the mediator, total cost of disbursements, an estimate of the anticipated costs, and an estimate of the likely duration and costs if it went to a final hearing. So all of that preparation needs to be done by the dispute resolution after court commencement. In addition to that, if it does not resolve, there's 2 things that you need to do as lawyers or parties. One is a written notice within 7 days of the dispute resolution event, identifying any changes to what are the issues in dispute, and you shouldn't be pursuing any unreasonable issues, the expected duration of the final hearing, and the expected costs. In addition to that written notice, which is really, again, setting out this cost notification and really focusing specifically on the issues in dispute, Rule 4.1 specifically states within 28 days of the mediation and also or after conciliation conference, a genuine offer to settle must be put forward. And if that is put forward, then the other party must make an offer as well. So really have a look at that 4.11 and 4.12. But I'll hand over to Tim briefly and I'll check if there's any questions there. Tim?
Great, thank you. I'm just going to share my screen again. So just quickly, let's have a look at how you would go about compiling your confidential case outline document that we've just been talking about. So you can see my matter here in Family Property. Back to more smart forms, and we've got the confidential case outline here. Now, just to let you know, we have had a generic case outline document in Family Property for a little while, so that's not to be confused with the confidential case outline one that you'll find here in the list as well. So if you click on this, again, a smart form will appear helping you fill this out, and you can file this either as the applicant or the respondent or other party. You'll see that information, again, like all the other smart forms, the information is flowing through that you've already collected once in Family Property. I guess one of the good things about this is that there is a bigger overhead in the kind of court forms and documents that you need to compile. So double handling information and reducing the risk for error becomes even more important. And so something like Family Property certainly helps you there because it reuses the information. You put it in once and you reuse it multiple times. But you can then go through and fill in that information that's needed, like the documents that are relied upon. You can nominate whether it's parenting proceedings and then fill in the additional information around best interests, current arrangements, and domestic and family violence just by clicking in add and providing additional detail as needed. You can indicate that it's for financial proceedings too. And then just provide the information here needed for the case outline that you wish to submit. Again, it's doing all the calculations for you. So based on the balance sheet there and what we decided we were going to sell, retain, divide, or transfer, it's automatically calculated the division, but it is listing the items here that we are indicating we want to retain or retain a percentage in. And we can nominate whether we agree or disagree across the parties there. So it's automatically collated that chronology and the rest of the information. And so if I click download, let's just have a really quick look at this document because it's quite new. So again, just a Microsoft Word document. Hopefully you can see that there on my screen. So all the information has gone in there. Let's just skip down. Yeah, so this is obviously a really important one, which is the balance sheet that is embedded into this particular document. And you can see that that has been compiled in its entirety from what you saw on the screen there moments ago with all the totals added up, saving you a lot of time. And then the list of property to be retained by you has also been pre-populated in there for you. So that's that court form there. Again, Microsoft Word file. You can then review that and make any amendments as needed in there. So any questions?
There was a couple of questions around consequences of non-compliance. I guess it's in regards to the central practice direction. It's not, in fact, the rules, it's the practice direction, but I'm going to be a lot firmer as a mediator on compliance with that 7 days and the documents requested. And I know for myself, we need to make an assessment of whether in these dispute resolutions post the commencement of court proceedings, we need to complete that form to say that whether they've made a genuine effort, and if they turn up not having done the preparation, or the mediation has to be postponed because of their lack of preparation, that may impact the ability for me to be able to say that they've made a genuine effort. So happy to have further discussions on that, Jessica and Julie, at some stage, but I think we need to be aware of what the practice direction says, and try to discuss that with our clients and the lawyers. So I think we're nearing the conclusion, but just to share my screen, as far as an overview, what we're seeing, Therese, is that the fact that the registrars have been given quite significant enhanced powers, and we're really looking at the judges' work being reserved really for the final hearings and for reviews, and for these pre-action, first court event, interim hearing, dispute resolution and compliance. It's all going to be conducted by what's now called the judicial registrars and senior judicial registrars.
Yeah, that's correct. And I think that unless your matter is already before a judge, anything new, you're not going to be seeing a judge for a while unless you satisfy specific requirements, such as matters being in specialist lists, or particular issues that mean that they will be automatically referred to to Division 1.
Great. What happens with legal aid clients, non-compliance and costs? Therese, from a legal aid perspective?
Look, there is, if I was going to go over this, but I will just refer people to Rule 12.05 and 12.06. Those rules there, and that's on slide 22. Fiona, if you just really quickly wanted to jump to that, just go back up a bit and click on to, back down one, and then if you just click onto that. So these are the first rule is in relation to 1205. Sorry, Fiona, if you just scroll up a little bit further. Yeah. So this is the duty to inform your client in relation to the actual costs, any estimated future costs. And this is really around the court wanting parties to understand very clearly what the costs are involved if they do not settle out dispute resolution and then continue to proceed. And so if we go to Rule 12.06, before each court event, each party has to file a notice regarding their costs 1 day before each court event. And again, that goes through those different factors in relation to costs. But if you are legally aided, you're not required to comply with that, and you're also not required to comply with that unless you're an ICL. But it does go on to have particular rules in relation to the types of cost notices that you need to file once you hit a final hearing.
Great. Thank you. Question was asked around, do we have to pass on offers as mediators? Yes, we should be passing on offers if they're made, but also just to reiterate, after a dispute resolution event, including a mediation, a formal offer has to be made pursuant to Rule 4.1, which is a compulsory offer to settle, and you should specifically refer to Rule 4.11. So that's 28 days after a conciliation conference or mediation, or 28 days after the first court event, or otherwise as ordered by the court. Just conscious of time, just wanted to highlight the features of family property. We obviously haven't been able to showcase everything to you today, but really keen, if you're interested, to do a full demo with our lovely Chanel, Business Development Manager. Do you want to turn yourself on there, Chanel? Family property really assists with various parts of the family law process, including intake, which is that questionnaire that Tim showcased at the beginning, including provision of that mandatory information. Costs agreement can be linked to that, other information. Disclosure, so we've showed you the recommendations around parenting. Now under the rules, the parenting disclosure that's required, the financial disclosure. But we also have, in addition to the client portal, we've got a two-way disclosure portal where you can actually provide that information to the other side's lawyer, and the other side's lawyer, even if they don't have family property, they can disclose it back. We've then got the dashboard, so the parenting calendar, which Tim showcased, adding in that information and then having a visual calendar on a fortnightly or monthly basis to showcase the general parenting arrangements, the parenting arrangements during school holidays, special occasions, etc. And then the balance sheet to model what's a 50-50, what's a 60-40, what if we take out this asset, etc., etc. And then, of course, the automated documents that Therese is busy developing with the techies, particularly in light of the FCFCOA. So, Chanel, did you want to just share what does a demo mean? What do you do?
Hi guys, I'm Chanel. I'm sure some of you might already know me. The demo, I just take you through the product from end to end and show you whether you're a lawyer or mediator, how to use it. If you're interested in booking in a demo, just email me on chanelf@familyproperty.com.au or call me on 0406041474. That sounded like an ad, but I am a salesperson, so that's what you expect. Thanks guys for everything, and yeah, I'll let you all go.
Okay, well, right on time, and we didn't practice from beginning to end, so it was good. We got through it all. So a big thank you. We did have a very good turnout today, both on Zoom and Facebook Live. We are looking to run some more webinars on topics of interest. So please reach out to us. We really take a client-focused approach to the product and these webinars, so love to get your feedback. And I'll stop the screen now and I'll end it both on Facebook Live and the recording. Thank you, everyone.